The moment a DC resident notices their spouse can no longer track finances or repeat instructions, a very specific fear surfaces next. Namely, can I even get divorced if my spouse has dementia?
This explainer covers whether a DC divorce is possible when one spouse has cognitive decline, what the court requires, and what happens to federal retirement benefits and estate planning documents along the way. The direct answer is yes. However, whether the divorce can proceed turns entirely on legal capacity under DC law. It does not turn on the medical diagnosis itself.
The standard the court uses is functional. The judge has to determine if the spouse with cognitive decline can meaningfully understand the nature of the divorce. They need to be able to communicate their preferences about property and living arrangements. They also must be able to work with an attorney and participate in the case. A person in the early stages of cognitive decline might retain full capacity to consent to divorce terms. Someone with advanced dementia almost certainly cannot.
If your spouse cannot meaningfully participate, the DC Superior Court must step in. This is handled through an intervention proceeding under DC Code Section 21-2011. It is a mandatory step to protect the incapacitated spouse's interests.
The court uses two distinct mechanisms here. In many divorce cases, the court appoints a guardian ad litem. This is an individual who represents the incapacitated spouse's interests, specifically for the divorce case. In more serious cases involving advanced decline, the court may appoint a general guardian. A general guardian has much broader decision-making authority over the person's health care and finances.
That guardianship process typically takes 30 to 60 days. It costs $5,000 to $15,000 or more in attorney, examiner, and visitor fees. This entire process must be resolved before the divorce can meaningfully move forward.
This is a situation that frequently catches families off guard. DC courts view this as an inherent conflict of interest. The court will absolutely not accept this arrangement. You cannot use your power of attorney authority to sign divorce documents on behalf of the spouse you are divorcing. The impaired spouse requires an independent representative. That representative might be a new power of attorney agent, assuming the spouse still has the capacity to designate one. But if they lack capacity, it must be a court-appointed guardian or a guardian ad litem.
The full article breaks down the exact guardianship filing steps and the Medicaid spend-down numbers, and it's linked in the first comment below.
Living in the D.C. area means a high concentration of federal workers, which introduces unique legal complications. Your retirement and health benefits require highly specific legal handling during a memory care divorce.
Federal employees carry extra steps. The FERS pension needs a court order acceptable for processing, or COP, before the Office of Personnel Management will divide it. The TSP account needs its own separate retirement benefits court order. And FEHB health coverage has to transfer within 60 days of the divorce, or there is a coverage gap. These are highly technical documents that a cognitively impaired person cannot review without court-authorized assistance.
We also have to confront the financial reality of ongoing care. Memory care runs $72,000 to $120,000 or more a year in the DC metro area for a facility. Full-time in-home care costs $55,000 to $85,000 annually.
DC courts will not approve a property settlement that leaves the impaired spouse without enough resources to cover these staggering ongoing care costs. Every financial aspect of the equitable distribution will be subjected to extra scrutiny by the court and the appointed guardian.
This brings up the complex topic of a Medicaid divorce. Medicaid only covers long-term care after strict asset limits are met. This requires couples to spend down significant assets before coverage applies.
DC Medicaid reviews the prior 60 months of asset transfers. The agency strictly penalizes anything structured to move assets away from the spouse applying for long-term care coverage. Getting divorced does not bypass this look-back period. The asset division in your divorce settlement will be highly scrutinized by the agency. Before choosing divorce specifically for Medicaid purposes, you must consider other legal tools like irrevocable trusts or annuity conversions.
Let's set clear expectations for the timeline of a gray divorce complicated by cognitive decline.
A standard uncontested case in DC takes 30 to 60 days. A DC divorce involving dementia usually runs 6 to 18 months. This extended timeline is driven directly by the required capacity evaluations, intervention proceedings, and the deeper court oversight of property division. Finally, you have to address your estate planning. Divorce does not automatically cancel a power of attorney or healthcare directive in DC.
Those documents, along with the will and beneficiary designations across all retirement accounts and life insurance policies, need to be updated immediately. Do not wait until the divorce is final to make those updates. A dementia diagnosis alone does not block a DC divorce. It does, however, fundamentally change the legal process, the timeline, and what the court requires before it will sign off. Please check the full article in the first comment for the complete guardianship process and the federal benefits breakdown. I also invite you to subscribe if you want DC family law guidance like this without having to search for it every time a question comes up. Ultimately, a gray divorce complicated by memory loss isn't just a legal procedure. It's a profound restructuring of a family's future. Are you legally and financially prepared for the road ahead?